Hello and welcome from me, David Foster. When you're being investigated for alleged war crimes, put shackles on those looking into the supposed wrongdoing. That's what the United States has done, imposing sanctions on two senior officials at the International Criminal Court. The question is, what, if anything, does the US have to hide? This is Roundtable. The chief prosecutor and an assistant at the ICC will be denied visas, and any assets in the US that they have will be frozen. Anyone helping them could also be targeted.
Has the US committed war crimes in Afghanistan? That's what the International Criminal Court is trying to find out, and what the Trump administration is trying to stop. Sitting since 2002, the ICC investigates and brings to justice those responsible for genocide, crimes against humanity, and war crimes, intervening when national authorities cannot or will not prosecute. It's the court of last resort. And although the US has never joined the court, previous US administrations have at times cooperated with its work, supporting investigations into crimes in the former Yugoslavia, Rwanda, and Cambodia. And current ICC cases include the examination of Myanmar's targeted ethnic cleansing against 700,000 Rohingya Muslims. Could this decision by the US undermine the court's credibility and encourage others to follow suit? And how will this impact international justice and accountability?
Well, now from Washington, D.C., we welcome Steve Groves, former Special Assistant to President Trump, one-time Chief of Staff for Nikki Haley during her time as UN Ambassador for the United States to New York, where we welcome Jennifer Trahan, Clinical Professor of International Law and Human Rights, New York University's Center for Global Affairs. Back to Washington, D.C. And we see there Liz Evenson, Associate Director in the International Justice Program at Human Rights Watch. Welcome to you all. Steve, if I can come to you first of all. US Secretary of State Mike Pompeo called the ICC a kangaroo court. He went on to say, and we'll see it on the screen, a spouse behind bars for defending freedom, a son or daughter robbed of their mom or dad, all on the initiative of some prosecutor in the Netherlands. Making sure this doesn't happen is the essence of America First foreign policy. Now, if, as you say, the United States has properly investigated any wrongdoing and has properly punished any transgressors, what spouse or mum or dad has anything to fear if the ICC continues an investigation, because all the wrongdoing has been punished?
Well, that depends on whether the ICC is willing to accept what measures the U.S. government has taken over the years, not just with the current administration, but with the Obama administration, to investigate and punish and try through courts martial or other ways the offenses that the ICC is investigating. If the ICC decides that what the U.S. did was not sufficient to try or punish these offenses, then they reserve the ability and the right to hold their own trial against these particular offenders on the allegations and come to their own decisions about whether they should be punished through their international court.
Well, pretty reasonable, surely, that if they discover in their investigations that there has been some wrongdoing, then that should go before some kind of court, some kind of tribunal, in this case, the ICC.
Well, it's reasonable from their viewpoint, of course. But as you know, the United States isn't a party to the Rome Statute and hasn't subjected itself to any part of its jurisdiction. So I understand from their standpoint that they feel that they have the need and the ability to try and investigate these allegations that took place in Afghanistan, because Afghanistan is a states party. But since the United States is not a states party, we are well within our rights of not accepting its jurisdiction or its efforts to come after American servicemen for alleged crimes in Afghanistan.
I'll come back to you in a little while, if I may, and ask you about your statement that this is in the national interest, national security. But Jennifer, let me come to you. I noticed one of the things that you've said is that if the United States believes in international justice, it cannot be immune from it.
Exactly. The U.S. has been a leader in the field of international justice, leading the prosecutions of the Nuremberg Tribunal, Tokyo Tribunal, very supportive of the Yugoslav Tribunal, Rwanda Tribunal, providing prosecutors, most of the prosecutors for the Sierra Leone Special Court, the Cambodia Tribunal now being led by a U.S. prosecutor. So the U.S. has really been a leader in the field. So it's just too hypocritical when the spotlight is shown on the U.S. Instead of engaging with the court and taking these allegations seriously, the U.S. comes out with strong-arm tactics, and instead of dealing with the rule of law, puts sanctions on court officials and attempts to strong-arm the court and block the Afghanistan investigation.
But does it not have every right to say we've done everything we can? We think there is nothing more to be discovered. It's a waste of time. It's a waste of money. What is the point in risking American people perhaps being prosecuted wrongly? This is the US view. Does it not have that right?
Yeah, the U.S. has every right to engage with the court and make these arguments. It's called under the court complementarity. Has the U.S. done this? Now, we have extensive documentation of the CIA torture program by the U.S. Senate Select Committee on Intelligence, but the full version of that report is hidden in some vault in Washington. So it's pretty clear the U.S. has not dealt with these allegations. They're not just against the military, it's also regarding the CIA. And if there have been a handful of military prosecutions, and this suffices, the U.S. has a way to engage with the court and say, you know, this is what we've done, put this forward. Instead, the U.S. has decided to threaten the court, threaten those who assist the court, render services to the court, to freeze the assets of the prosecutor. And these are techniques the U.S. typically uses for drug traffickers and terrorists. And now we put them on the officials of a judicial institution. It's just, you know, beyond the pale.
Liz, let me come to you. And this is not so much about human rights, but we will talk about those as well. But this was always coming, wasn't it? Because although President Clinton was the first person to sign up to this, successive presidents have either said, well, look, we don't like it, they've prevaricated, or they've done now as Donald Trump has done and sort of openly challenged the court. It's not just a Trump issue, is it?
I think what we've seen, as Jennifer just said, in terms of actually using this incredibly coercive power that the U.S. has in its sanctions regime against an international judicial institution, is a departure even from what has been not at all a static relationship between the ICC and the U.S. It's been very dynamic. It's been very contested, particularly in the earliest days of the court's existence, when the then Bush administration was trying to use U.S. assistance to dissuade courts from joining the court or to join agreements that would immunize Americans from the court's reach. That was a very contested and hostile moment. But the Bush administration, and in its second term, came to realize that the court had real value. It did not stand in the way of the UN Security Council taking up an investigation in the situation in Darfur, and it actually stood behind that investigation through the end of the Bush administration. And that approach then in the Obama administration became more and more constructive and even supportive towards the court, helping, for example, to assist in the arrest of two individuals who were wanted by the ICC.
When you talk about real value, more than $1.2 billion spent, less than a handful of people behind bars for an institution that's been going, well, almost 20 years.
It's absolutely right that, and I think many people perhaps know that the court has had a lot of troubles. It's been around for 17 years at this point. It's faced a number of setbacks in the cases. This is not entirely of the court's making. It's an international court. That means it relies on governments for cooperation. So there are more than a dozen arrest warrants that are outstanding that have not been executed. There hasn't even been a chance for victims to see their day in court because there hasn't been cooperation in arresting those individuals. But it's true that when it comes to some of the court's cases, the prosecution has faced setbacks, and that's something that needs to be addressed. And I think,
and there is going to be a review, I believe. Let me just say this to you: if it has all of these failings to its name in the 17 years that you talk about, perhaps the US is right to mistrust it.
Well, I think what we've seen is that that's not the view of ICC countries. The 123 countries that belong to the ICC, including the United Kingdom, they've been very clear in pressing back on this use of sanctions against the court. There is an ongoing process right now to look at the court's performance to strengthen it. But I think the message there is we need this court. We see the normative value that it is exerting all the time. There are many different justice processes that are happening in part because the ICC is there, and it stands for the principle that the international community will not tolerate impunity for the worst of the worst human rights violations. And we've seen ICC member countries make clear that they are remaining behind the court and they are undeterred by the US's threat.
Steve, these files that are in a vault underneath Capitol Hill, perhaps, or somewhere else, that supposedly detail torture committed by US personnel in Afghanistan, is that what is believed to be in the national security interest, not letting that come out?
Well, that's really a matter for Congress to make a decision on. Those reports that are just heavily redacted, that's not the executive branch. That's members of Congress who've decided to keep those parts still classified. What's in the U.S. national interest and is to engage with the court, which it's doing. I disagree with that we are not engaged at all. Secretary of Defense Esper, in his recent press conference, along with Pompeo and Barr, said to the ICC, welcome, send the allegations that you have to us. We will review them and engage in that manner. The sanctions on the prosecutor notwithstanding. So what's in the national interest of the United States is to protect its foreign nationals, but to try them for offenses that they commit in war zones, whether they be war crimes or crimes against humanity. And there have been many court-martials from detainee abuse in Afghanistan and hundreds of other actions short of a court-martial taken against U.S. military personnel. So this is a process that is in flux. It's clear that the ICC prosecutor.
If I may just ask you, when you worked with President Trump, his attitude to the ICC was what, more explosive perhaps than some of his predecessors because he believed in America first? He was more volatile perhaps than they were. What were his thoughts that you gleaned?
I think neither of those. No president has embraced the ICC, Democrat or Republican. When Clinton signed the Rome Statute, he did it with heavy caveats. Bush came on and unsigned the statute to remove our name. President Obama was in office for 8 years and took 0 steps to join the Rome Statute. What happened in the current administration is there was a change of circumstances. The ICC turned what had been kind of a preliminary review that had begun back in 2006 into a full-blown investigation of U.S. actions in Afghanistan. That's a changed circumstance, and the president acted according to that changed circumstance by issuing this executive order and sanctioning individuals.
Jennifer, let me ask you, is this going to make the work of the International Criminal Court in trying to track down and trace any wrongdoing that is suggested perhaps to have come from American and, we understand, other forces out there as well, its allies and the Taliban, is it going to make it much more difficult?
Yes, I mean, it's just not following the judicial process. If there is all this engagement going on with Washington, this would be welcome. But when court documents are hidden in a vault underneath the Senate, I think it's fairly clear that the U.S. is not in good faith engaging with this conduct. But just to go back to the previous speaker's statement, he said the Obama administration, they did nothing for the U.S. to join. Now, the U.S. hasn't joined, but the Obama administration pursued a policy of constructive engagement on a case-by-case basis with the court and was actively helping the court in pursuing these cases, such as the case involving the Lord's Resistance Army. The U.S. sent Special Operations Forces to try to track its members.
That's Uganda.
That's
just for everybody out there.
Or working with the military in Uganda, wherever the LRA had gone into, assisting in turning over an individual who surrendered himself to the U.S. Embassy in Kigali, did end up in The Hague. So the U.S. was quietly assisting a number of the ICC's cases. And even this government suggests some of the ICC's cases should proceed. Pompeo himself was talking about the importance of seeing justice for the Rohingya in Myanmar. Now, this is one of the cases on the ICC's docket. And when you put sanctions against the court and make all of the court's work more difficult, you make it very hard for even a case involving the Rohingya to go forward. You make it hard for the Darfur case to go forward. The U.S. was one of the first countries to come out and say the crimes of Darfur were genocide. And now we do have one individual from the situation who's been apprehended, and this case can finally proceed. And the U.S. under the Bush administration supported justice for the crimes in Darfur. And the problem is when you strong-arm the court, you put sanctions against the court officials, potentially against the institution or anyone who aids the court. These are very, very broad sanctions. Anyone who gives material assistance, you make all the court's work much more difficult.
This is an ICC statement. The court would continue to, as it put it, stand firmly by its personnel and its mission of fighting impunity for the world's most serious crimes under international law, independently and impartially, in accordance with its mandate. Liz, there is a review coming up. What needs to be looked at? Is it its independence? Is it its impartiality? What?
The review that's going on right now is a very important process. There's a panel of experts that was commissioned by member countries to look really right across the court's work and to see what could be done to strengthen the court. That is the goal, to strengthen it in being as effective as possible in fighting impunity for these crimes. The report of that expert panel is actually due next week. So we'll have to see what areas and what recommendations they make. But we would expect and hope that their recommendations that will strengthen investigations, that will strengthen cooperation from states, overcome some of the challenges we've seen in getting cooperation, that will also look at ensuring the court has a strong connection and relationship with victims and with affected communities who are at the heart of this court's work and are oftentimes at a very far distance from the court.
Fascinating to see what does come out of that review. I'm going to come to you now, Steve, if I may. And Liz, you might want to respond to this because you represent an NGO, a charity looking into abuses in many parts of the world. Steve, you have suggested that you're worried about what you call politicization of any kind of investigation stroke prosecution by, among other people, NGOs. Have you seen this?
Well, politicization is part of this process. International courts that go after war crimes, it can't be separated from the politics of the era. I mean, the Nuremberg trials couldn't be separated from what the politics were in post-war Germany.
But you've suggested there's pressure from NGOs in these types of situations as well.
Well, sure. I mean, that's the job of NGOs. Human rights activists and the NGOs they work for are firm believers in this court and how it should operate and go after these war crimes and crimes against humanity, including those that the United States is accused of. So, it'd be, pressure, politics, it's all part of the same way, in a way
but
that
rightful pressure or undue pressure?
I mean, pressure is pressure. They would call it rightful. Whether it's undue or not, I leave to others. That's the function of NGOs, and I take no issue with them putting pressure on the court or pressure on countries to, including the U.S., to participate and join the court. That's how NGOs work. I work for an NGO, and we put pressure on political matters all the time.
Liz, do you want to respond? Well, I think what would be helpful maybe is to take a step back and look at how the court works. It is definitely the role of organizations like my own to try to push for accountability, for justice, for victims of war crimes, of crimes against humanity, of crimes of genocide, and to look for all of the avenues that exist. I don't think that's a politicized agenda or a partisan agenda, but you also have to look at this, that it's a court. And there are so many checks and balances and safeguards built into the system. If we look at the investigation that's been authorized in Afghanistan, that was something that the prosecutor had to make a request to a panel of judges to approve. They initially refused that permission. It went up to an appeals process. There were a number of friends of the court that appeared before that. And if the investigations go forward, they're actually on pause right now for a number of different reasons. If they go forward, there's a very long process with a number of fair trial rights enshrined within it. And so I think that we're talking about an independent judicial institution, the creators of which were countries themselves, really were trying to look very carefully to make sure that it couldn't be politicized, that it couldn't be used in the service of agendas of states' parties, let alone NGOs.
So, Jennifer, let me come to you on this one. If there is a change in the White House come November, January, when the new president takes office, if that happens, will the US's attitude to the International Criminal Court change in any meaningful way?
Yes, I think it will. I would expect that a new administration would hopefully reverse the executive order and not pursue any kinds of sanctions. I'm sure a new administration would also want to engage with the court if there are jurisdiction arguments to be made or complementarity arguments to be made. I would expect that level of respect, engaging with the institution, and certainly not sanctioning the individual at the court who are just trying to do their jobs that they're tasked to do, their mandates, and follow their judicial mandates.
Thank you very much. Steve, let me come to you. You believe, I think, that the court is still relevant, but if there is a new person in the White House, will the same approach be undertaken?
Well, I don't expect that a Biden administration would make any moves to join the court. I expect that they would continue the current policy that if the ICC is going to pursue this investigation, that they should turn over what evidence they believe they have against U.S. personnel and let us review it. Secretary Esper has invited the court to do just that. I expect a Biden administration would do the same. Whether they'd remove these sanctions against ICC personnel remains to be seen.
It is sort of impugning the integrity of the court, is it not?
Well, it's impugning the integrity of a court that doesn't have a legal existence to the United States. I mean, we're not a party to the Rome Statute. As far as we're concerned, this is a court operating out of The Hague on its own steam. It doesn't have any jurisdiction over the United States. We haven't consented to it. So you can call it impugning if you like, but the United States is using its instruments of sanctions to express its displeasure, and it's got a sovereign right to do so.
Liz, let me come to you for a final word. I'm sorry to have to ask you to make it brief. Could this end happily for both parties?
I think it's important to understand there's really nothing unusual going on here. U.S. citizens that commit crimes overseas are subject to the jurisdiction of other foreign courts, and the ICC is drawing on that power. And I think it's also important that to understand that there really hasn't been meaningful action before US courts for the kinds of abuses that were committed in Afghanistan by US personnel, let alone if we talk about the impunity for the other kinds of conduct that could be investigated here, the indiscriminate attacks of the Taliban, abuses by Afghan national forces. That's what's really hanging in the balance here, is the access
There's
of
been scores of
access
court martials. I do have to interject and say there have been 70 courts martials. So it's not, there's not impunity here. There have been investigations, there have been trials, there have been punishments.
And how many of the CIA?
At which point, I'm terribly sorry, which point we're going to have to say come back another day if you want to make any further comments on this program. We are bound by the constraints of time, and we've heard the clock strike midnight from our program point of view. Thank you very much for coming on the program. That is it from me, David Foster. Thank you for watching wherever you happen to be. Hope to have your company next time. Until then, goodbye.